Our submissions basically is based on the powers in the Courts of Judicature Act, which grants the court additional powers to review any decision by a statutory body or the action or omission of any public authority. And we do not see any concrete reply to that submission from the AG Chamber. And we also have submitted that in matters of constitutional issues, the court cannot decline jurisdiction and must cease jurisdiction. This also follows from the recent federal court decision of Indira Gandhi, where the court says that in all matters where it concerns constitutional matters, it must cease jurisdiction and cannot decline jurisdiction. Further, we also have raised the point that our matter can be distinguished from all the earlier line of court appeal cases and the federal court case on Monday, because in all those other cases, the applicants are individuals, voters and members of parliament. But in our case, our matter is filed pursuant to the purview of the State Legal Advisor and under the State Legal Advisor's blessings. And that makes us an applicant who should obtain leave almost as of right, as the SLA is a seconded officer from the AG Chamber. And at this ex parte leave stage, EC has not come into the picture yet, and the only person who is objecting is AG Chamber. And that is inappropriate, having in mind that the SLA is a seconded officer from the AG Chambers. They should act in unison and not have a conflict of opinion as to whether this action shall be filed. And also we have submitted that according to the federal court case of Zamri, we have submitted extensively on the fact that the declaratory power is available to court in all situations. And even in the case of boundary commission, such as that in the food case in England, Zamri case has adopted the food case, and hence the food case should be part and parcel of the Malaysian law, which says that the recommendations similar to ours, recommendations of the boundary commission, which is the counterpart of the election commission, can also be reviewed. Although on merits the case was dismissed, but at least it is said in food case that leave was granted, and it is not non-justiciable. So our point is that EC is no different from all other public authorities. It shall not be immune to judicial review. It cannot be that EC is so special, having a superposition that judicial review cannot touch, and that its action and omission cannot be non-justiciable and cannot be immune from scrutiny from the court. And what more, it must be borne in mind that our appeal today is only concerned the leave application at Penang High Court. It is not about the merits of the case. We are not saying that for sure there is gerrymandering or malapportionment or the non-maintenance of local ties, but we are raising this as concerns and issues of constitutional importance, and that all we are praying for is for leave to be granted so that EC can come and respond. You will note that until now, the EC does not need to come and respond because it's only the ex parte leave stage, and AG is the one fighting us. And that is, I would say, preposterous, because SLA, whatever you call it, is part of AG. And SLA has given its go-ahead, and SLA must have taken into account public interest concerns and circumstances of the case and merits of the case. So this case cannot be unmeritorious, cannot be frivolous, and the threshold for granting leave is very low, as we have submitted. No meritorious examinations of merits need to be conducted at this stage. All the court is concerned is that we are not busybody, we are not frivolous, and by dismissing our appeal is tantamount to saying that our case is frivolous, which we find unacceptable, and our client is, meaning Penang government, would be considering taking this matter a step further, meaning to apply for leave to appeal to the federal court.